the previous lecture, we have discussed about protection of minority rights before the League of Nations. In today's lecture, we are going to discuss the topic minority rights under the Covenant of League of Nations. To introduce the topic, in the aftermath of the World War I, the claims of national groups, both large and small, dominated the international relations. The claims range from demand for equal treatment at par with majority population to granting of independent statehood. The demands were rooted in historical, territorial, political, and ideological claims. In the light of these claims, the issue of majority and minority was fast becoming a subject of crucial importance. In order to understand the contribution of the League towards the protection of minorities, the Covenant of the League of Nations can be discussed. To start with, the premise of the League Covenant. The Covenant or the Constitution of the League of Nations was adopted by Paris Peace Conference in April 1919. Discussing the framework and the role of the League of Nations in addressing minority rights cannot be done without introducing the context and legacy of Paris Peace process. The framework of the conference pioneered significant approaches to negotiating international conflicts as it dealt with settling of maritime rights, trade, disarmament, and national rights. At the Paris Peace Conference, a special committee was appointed to agree on a covenant of the League. In other words, the urgency to address minority rights was heightened with the large-scale displacement, dates, redrawing of political boundaries. It also dealt with issues like trafficking, slavery, prostitution, women and labor rights, and rights of the stateless people, etc. For example, the Treaty of Versailles reportedly gave 60 million people a state of their own for the first time in the history, while creating another 25 million ethnic and linguistic minorities, which later on became an integral part of the League's covenant. Let us now talk about the issue of membership and location of the smaller states in the context of League covenant. It can be argued that the spirit that was in circulation towards the second decade of the 20th century emphasized the need to respect for national aspirations with self-governance. The advocacy of self-determination began to realize the source of the World War I as caused due to the disregard of the rights of the small nations and nationalities. As per the League Covenant, there are two important categories of membership. The first one, there was a group of signatory powerful member states on the one hand, and on the other hand, self-governing countries including dominions and colonies. The admission of the dominion and colonies into the League was to be voted by a two-thirds majority of the state represented in the League. Now it becomes very interesting to talk about the deliberations of the Covenant in terms of actual practice of the League Covenant. It can be said that the functions and activities of the League are derived from its covenant. The founders of the League resolved to promote international cooperation and to achieve international peace while obliging the members not to resort to war. The covenants of the League consist of 26 main articles. The majority of the articles deal with interstate relations with some commendable references to minority rights. A select discussion of the covenant articles with reference to minorities can be brought out here. To start with, we are going to talk about Article 1 of the Covenant. It lays down the guidelines for League's membership. It reads, I quote, "Any fully self-governing state, dominion, or colony not named officially may become a member of the League if its admission is agreed to by two-thirds of the Assembly." Article number 1, unquote. The Article 1 guarantees easy access and membership to all the countries in the world irrespective of their political status. Article 4 and 5 Clause 1 can be discussed in the context of international peace and minorities. According to the Article 5 Clause 1, decisions of the Assembly or Council will require the consent of all the members of the League represented at the meeting. The Article 5 Clause 1 says, I quote, "Except where otherwise expressly provided in this covenant or by the terms of the present treaty, decisions at any meeting of the Assembly or of the Council shall require the agreement of all the members of the League represented at the meeting." Unquote, Article 5. The proposition of the Article 4 and 5 was the provision for the minority communities and even the colonies to register their voices. The articles allowed them to send a representative to attend council's meeting, particularly if issues affecting those members were to be discussed in the League. Now let us talk about the League Covenant in the context of weaker states. Under the Article 10 of the League Covenant, the members were to stand against external aggression, protect the territorial integrity and existing political boundaries of all League members. Article 10 provides a protective shield to the member states, including the weaker and poorer states. The Article 11 Clause 2 and Article 13 further supplements that members shall have friendly right to bring to the attention of the Assembly or of the Council in any circumstances which might threaten to disturb international peace. The intention of the creators of the League was that disputes should be settled judicially. In this regard, it can be mentioned that according to Article 12 of the Polish Minority Treaty, any difference of opinion as to the question of law or fact arising out of the Minority Treaty articles could be brought before the Permanent Court of International Justice, also called as PCIJ, for discussion. The court could give a decision and it was clear that Council would follow such a decision. The role of PCIJ is significant as it could give advisory opinions to settle issues concerning minority rights. Another important aspect that can be brought here in is the context of Article 13 Clause 1. The article deals with the settlement of disputes through arbitration, or also called as judicial settlements, in the cases where diplomacy were to fail. Under the Article 13 Clause 3 and 4, any such dispute would be referred to the PCIJ, and members of the League were expected to endorse in good faith any award or decision rendered by PCIJ. It will be also equally interesting to talk about Article 16 of the League Covenant, because it talks about avoiding wars and protection of minority members. For example, Article 16 provides that should any members of the League resort to war in disregard of its covenants, under the Article 12, 13 or 15, it shall, if so facto, be deemed to have committed an act of war against all other members. The League had the power to undertake steps to severance of all trade or financial relations and prohibition of all diplomatic relations in case of violating League covenants. An interesting scope of this stricture was that it could be applied to League members and non-member states as well. On the other hand, Article 15 further says if both parties agree to bring the matter before the arbitration court, they can do so. If they don't agree, it becomes before the Executive Council. Accordingly, any state that considers its interests better represented in the Executive Council than in the Court of Arbitration has only to put its veto against the court, and forthwith the case can be transferred to the Executive Council. The Article 16 significantly underscores the League's commitment to punish the members of the League as and when they violate covenants. the Article 16 provides a crucial shield to the rights of the minorities. The article was a great relief to the militarily and economically weaker countries, that it advocated strong strictures on powerful countries with imperial ambitions. It is also equally interesting to talk about Article 17 because it talks about offending of the League Covenant. In the event of a dispute between a member of the League and a state which is not a member of the League, or between states which are non-members, shall be invited to accept the obligations of the covenant. If such invitation is accepted, the provisions of Articles 12 to 16 inclusive shall be applied with such modifications as may be deemed necessary by the Council. To talk about Article 22, which talks about colonies and conditions of control, it can be said that Article 22 is also an important guideline to the protection of minorities. It reads, I quote, "To those colonies and territories which, as a consequence of the war, have ceased to be under the sovereignty of states which formerly governed them, which are inhabited by peoples not yet able to stand by themselves under the strenuous conditions of the modern world, there should be applied the principle that the well-being and development should be embodied in this covenant." Unquote. The Article 22 opens up a wide room for resurgence of formerly colonized states and minorities. However, the practical aspect was subject to several difficulties, as the advanced nations were to enjoy tutelage over such states and minorities on behalf of the League. The character of the tutelage was to differ according to the stage of development of the people, the geographical situation of the territory, its economic conditions, and other similar circumstances. In this regard, the case of certain communities formerly belonging to the Turkish Empire can be mentioned. Their independence was to be provisionally recognized, while administrative advice and assistance by a mandatory state until such time as they were able to stand alone. The wishes of the communities constituted a principal factor in decision of the mandatory status. For the sake of clarity, one can define mandatory system as a kind of a recognized arrangement under the League that empowered powerful countries to have control over the weaker states. For example, in the case of Southwest Africa and South Pacific Islands, owing to their sparseness of population or smaller size or remoteness from the centers of civilization or geographical contiguity to the territory of the mandatory and other circumstances, was regarded to be suitable to be best administered under the laws of the mandatory. Under the aegis of the Article 22, Central African states were also governed in similar ways, while protecting freedom of conscience and religion, subject only to the maintenance of public order and morals. The prohibition of abuses such as the slave trade, arms trafficking, and liquor trafficking. The article also enlists the importance of territorial defense of the states under the mandatories. The Article 22 lays down specific principles to render annual report by that particular advanced nation, also called as mandatory state, to the League Council with regard to the status of such a territory under its command or tutelage. The degree of authority, control, or administration to be exercised by the mandatory shall, if not previously agreed upon by the members of the League, be explicitly defined in each case by the Council. In order to increase the efficacy of the Article 22, there is a provision for a permanent commission to receive and study the annual reports of the mandatories, which enable the Council on all matters relating to the observance of the mandates. After having discussed various articles of the League Covenant, towards the conclusion, it can be said that for the first time in the history of the modern world, the League had begun to play an important role not only in terms of evolving a global theoretical premise on protecting minorities. Member states were expected to respect and preserve as against external aggression the territorial integrity of other members, and to disarm to the lowest point consistent with the internal safety of a country. The Covenant permitted the member states to submit complaints for arbitration or judicial inquiry if and when they face warlike situations. The post-World War I witnessed the emergence of relatively weaker and smaller countries such as Austria-Hungary, Romania, Serbia, Montenegro, with the granting of freedom of occupied territories and even creation of independent state in some cases. In short, it can be said that the philosophy and deliberations of the Covenant was not to make the League a superstate organization or a policeman of the world, but a platform for engaging international relations for peaceful and just conduct.